Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the losses of Rajiv Khanna PC. Today is August 6th, Thursday, 2015. This is our community conference call, which we host every other Thursday. Um, we'll be answering the questions that have been posted by the community first. And if time permits, I may be able to take new questions. Today is going to be difficult for me to predict whether I'll be able to take new questions or not, but definitely all the posted questions we'll be able to deal with. Okay, we have a few seconds left to 12:30, and now it's 12:30. Okay, my first question is actually a question that comes up quite a bit. And this is a question that has become more and more relevant as times for green cards have suffered from a few months to now several years for people born in backlogged countries like India, China, Philippines, Mexico, etc. So if I'm on H1, can I do business? Can I invest money? Can I, and there's a question at the end of this set of questions today, can I, for instance, do business through my wife who has an EAD? Let's look at the situation. What is H1? H1 is specific to an employer. Okay, you cannot have more than one employer without some kind of an amendment. There are two components to an H1, an employer and a true employer-employee relationship, which means in the context of a self-owned or a family-owned business, it is truly an employment. Somebody can fire you. So if you are yourself the president and the board of directors and the only stockholder, USCIS often does take that position. Nobody can fire you. Therefore, this is not really employer-employee relationship. Technically, a corporation is a separate entity than the individual. So if there is you and there is your corporation, these are two different people in the eyes of the law. But for immigration purposes, we need a situation where there's actual employment. Okay. Now, if I want to invest money passively, for example, let's say I want to buy stock in a publicly traded company, can I do that? I don't see any problem with that because all you're doing is putting your money in a long term investment. You're not doing anything active with that money. What if you were day trading? That might be considered to be a violation of your H1. I'm not sure. USCIS has never definitively commented on this. All we can do is make educated guesses where USCIS will go if this issue came up. So active trading might amount to violation of status, but passive investment would not. What if I want to invest in a business, a small business, where I will be, let's say, I'll be incorporating. I think incorporating is not illegal. You can incorporate because you're not making any money yet. If you look at employment as it is defined in the regulations, it is work done for remuneration or any other benefit. That's what employment is. Okay. But if you are not working for money yet, or any other benefit, and benefit here means more in terms of um, cash equivalent or cash, for example, if you're getting a tuition waiver or other kind of benefits that are equivalent to money, although they are not money. So I think when you have a situation where you are doing something organizational, just setting up a corporation, I don't think that's a violation of your H1. Once the corporation is organized, if you do anything, even sign a check or a lease, I think that would be a violation of your status. So what are the choices? Either go passive, do only passive investment, let somebody else handle everything else. Think that I have bought stock in IBM. What can I do? Can I run IBM? No. Can I pull up a chair in the board of directors and say, I'm here, I have $300 worth of stock, I'll help you manage the company? Of course not. So think of it as somewhat like that, where there is a distance between the investment and the control. When the distance between investment and control is small, that kind of a situation could be a violation of your H1. For those of you who have logged in late, I am addressing this issue. It's important, that's why I'm repeating it. Uh, I'm addressing the issue whether you can do business on H1. And so far, I've said passive investments are okay, active or not. So, what other situation could there be? Well, what if I have a green card holder or a US citizen who is running the company? They are the president. Even though I am 51% stockholder, can I be hired by my own company on H1, a simultaneous H1, a concurrent H1, part time or full time? I think you can. I would, if I were doing this case, I would make a representation to USCIS that look, we're not playing any games with you. I am the 51% stockholder, but this guy is running the company. I am going to act only as an employee. Okay. I can be fired by the president. That's very clear. And maybe even have something in writing that says, okay. So I think the second option of having an H1 in a truly employer-employee relationship where you can be fired through your own company would be permissible as long as you've gotten a proper H1 permission to work that job. Third option, which the last uh, question in this forum today, it's on page 2 of our discussions. I marked it because they are kind of similar questions. I'm on H1B, my wife is on H4 EAD. I want to start an LLC consulting business, have wife as an employee. I realize that I cannot start a business as an H1B holder. Um, and um, can she run the company, etc.? And the answer is yes. Why not? Once you have an H4 EAD or a 485 EAD, you can own the company, run the company. Nobody can stop you from doing that. That would be perfectly legal for you to do. So, once again, passive investment is okay. Being genuinely an employee of the company is okay. And even if a family member, number three, even if a family member is running the company, that's perfectly okay, even though you are the majority owner, as long as you can be fired and that's made clear on the record. Of course, you have to get an H1 for your own company. Okay. Now, folks, anybody has any questions related to this issue, press *5. Nothing new, no tangential issue, only doing business while on H1. Press *5. Okay. Let's move on to the next question. Lokeshji says, Mountain Hope is his title or his handle. I'm on H1B, 485 is applied for. Planning to visit India. What if the green card is approved when I'm in India? This happens all the time. If you are on advanced parole or on H1 or L1, you are in India, or any other country, your green card gets approved. There are two components to traveling back. One component is actually being able to get on the plane. To get on the plane, you need some kind of a valid status, whether it is advanced parole, H1 visa, L1 visa. Otherwise, the airline would not issue a ticket. Once you land in the United States, the second component kicks in. Because all your information should be visible on the computer screen, USCIS, actually CBP, can look at your case history and know that you've been approved for a green card, and they will let you in. I've had many, many clients in this situation, and they have not had, they might have to wait a little bit extra, might have to go through secondary inspection, another hour or two extra, but they've all come in without any problem. Okay. Um, does anyone have any question about this issue? *5. I've changed my routine a little bit. Now I just ask for the, okay, one question, because that way we can keep the entire discussion together for when people listen in. They were saying they had to go all over the place trying to listen to first my answer, then any other question asked. So let's go to this question. One second. Oh, I'm sorry, I messed something up. Can you press *5 again? I don't know what I did. Oh, no, you're on. Go ahead, please. Missouri, go ahead, please.
Hello.
Yes, sir, I can hear you.
Hi, this is Lokesh. Yeah, thanks for the answers for my two questions. I forgot to put one more question, so I'm going to ask.
Sure.
So this is like when they applied my 485, and I see that on my tracking that like Phoenix lockbox. So I'm trying to check my status. I don't know what is the difference between field office and service center. Should I, because Phoenix is come when I drop down, check the drop down, it comes under field office. So
Yeah.
I'm really confused whether that is the same thing I'm looking, or we need to just
I think,
where I need to look on.
see, I am a little fuzzy on the details of the current logistics. My team members know better than I do. But from what I understand, that the lock boxes, some of them are set up specifically to distribute cases to the field offices. Cases go to field offices in employment context when there is some further investigation needed, or sometimes they are random picks. Um, that's the typical scenario. Now, in order for you to track down the status of the case, if I were you, I would begin first with the USCIS General Customer Service Number. Okay, so call the General Customer Service Number, let them tell you where you need to go.
It's pretty early actually. They sent me like 2 weeks ago. I was just checking where it went and how many months it is taking in that particular service center or field office. So I will get a bit confused because should I look at the field office or should I look for a service center? Because when I drop down, check, there is no anything called Phoenix in the service center drop down. So I thought, okay, let me ask you so that you can give some direction for me.
I do not know the answer off the top of my head. Normally, I know that our team just calls the customer service when we have to open a case. But if you want an estimate, even then you could just call the customer service.
Oh, okay, okay.
Okay.
And another continued question, like, when I check this Phoenix Law of Field Office, it says last year process. Is that true? Because most of the forums say that 3 to 4 months nowadays they're processing 485, the priority dates are running down. But it says like last year, 2014. Is that true?
It probably has not been updated. Did you say 2014? Which month of 2014?
October.
So that's almost a year. I don't think that's true. Give me 1 second. Sumanji? No, I don't have to come. I'm on a conference. Very quickly, you think that 485 times are about 1 year after priority date becomes current?
I would say 8 to 12 months.
Thank you. 8 to 12 months.
Oh, thank you, Rajiv. I appreciate it.
All right. Good luck.
Thank you.
Guys, when I did my green card back in 1989, labor certification, I-140, 485, everything altogether used to take only 6 months. So you can imagine how bad things have gotten where we will have to wait 8 years, 9 years, 10 years. It's just, that's not how the system was built. The system was not built for people to have to wait 10 years. Everything is topsy-turvy. Okay, let's go on to the next question. Santosh, I'm on USA on L1B. Company B processed my H1B, got approved. I didn't join, but I traveled outside USA on 30th September, came back to USA on 4th of October. So before H1 kicks in, I am back to L1. The question is, am I quota exempt? I think you are. I think you are quota exempt because your H1 was not withdrawn / revoked by the company until after October 1st. However, I have some doubt about this. This is definitely not a clear-cut scenario. Um, I would want you to try it. I think it's going to go through as a quota exempt case. Okay. Can I apply for L1 to H1 conversion on the same petition? No, I think you'll have to refile the H1 because one of the questions that comes up is, was the job available? Did it continue to be available? If it is in-house employment, you might be able to apply for an extension and a change of status on the same case, or you can file just a new H1. seeking a quota exemption. Okay. The employer is saying that if we try to use the same H1, we may not be able to get an approval. So I don't know, that question has two components. There is a good likelihood that you should be able to become quota exempt. So that part is not that risky. But if you're trying to get an H1 on the same case that was approved earlier, it could be questioned that how was this job available? How did it continue to be available? It doesn't sound real that a genuine employer with a genuine job would wait for you for a year or year, 6 months, and you don't join them. Who's doing the job then? Okay. So quota exempt, probably yes. Same petition, probably not. If you are on the phone, press *5, Santoshji. *5 if you're on the phone. Okay. Let's go on to the next call. I'm a B1, B2 holder last 17 years, opened an LLC in Ohio. Company is linked with my Indian company, negotiated with a broker for a deal to take over a running franchise. Thinking of an L1, franchises, L1 are very difficult. There are problems there. Now, you had a question about adjustment of status. Now, remember one thing. Adjustment of status is like the second floor or actually the third floor of a building sometimes. Sometimes it's the second floor. Unless you have a ground floor or a floor one, you cannot go to second or third floor. The ground floor is an application such as a Form I-130 or an I-140 or an investor visa, whatever that 560, whatever that form is, I always forget. So you have to have some basis on which you have built the first floor. Only then you can apply for adjustment of status. So adjustment of status is not available unless you have a reason to claim a green card through some category, and that reason has been duly approved. So you can't directly file for adjustment of status, okay? And that does not help you. If you're on the phone, Sandeep Shukla, press *5. *5 if you're on the phone. All right. We'll go on to the next one. This is H1B 2015. Applied for H1B in 2015 with two different employers. Both got approved. I am outside USA, had my visa stamped. Now, visa stamped with A, A's project is delayed. Can I use A's visa to travel and join B? And the answer is don't do that. We've had this situation. We had a fairly lengthy exchange with the consulate, and consulate says, we consider this to be fraud. Okay. The case would be different. If you came into USA, worked with employer a few months later joined employer B, you could continue to use the same visa, although they prefer that you go apply for another visa. However, the law clearly says you can continue to use the same visa. But when you have not yet joined, knowing fully well you don't have a job with employer A when you enter and you intend to join employer B, they are not going to like that. Okay. So what are the options? I think you'll have to go back and apply for another visa, H1 visa, through employer B. If the consulate tells you you don't need another visa, great. Begin by sending an email to the consulate and ask them, this is my situation. Do you want me to come in for a visa stamping again? They say yes, you go in. Okay? If you're on the phone, press *5. I had a bunch of people from India today, I was noticing. Unusual for us. Normally, we have a lot of people from all over the United States. *5 if you're on the phone. All right. Let's go on to the next one. My brother, US citizen, had called parents years back. They kept coming and going. They used to take 2-year travel permits. So they've lost their green card because they've been outside for many, many years. Their green cards are valid till 22. I'm aware that they've not visited USA, so green card would have automatically expired by now. They don't have any medical records, so there's no reason, nothing we can use to justify why they were gone so long. I think what you'll have to do, sir, is Saf Sheikh. What you would have to do is have them surrender their green cards. Okay. If they want to visit, just visit, they can apply for a tourist visa. If they don't want to apply for a tourist visa, you can start their green card all over again. It takes between a year and a half, a little bit less, a little bit more, but that's the other route available. All right. If you are on the phone, press star 5. Anybody with a follow-up question on this, star 5. Okay. Let's go on to the next one. I'm sorry, this one, Georgie, I will not be able to answer. We don't do DV cases, lottery cases. I, in my entire life, did one case in DV lottery so many decades ago when the lottery first started. And I quickly realized, don't need a lawyer for this. So we've never done any DV cases. In fact, I don't know any lawyer who does DV cases. Okay. Next is from Chakri. Parents just received their potential interview waiver for their green card. However, the wait to get the green card will take up to 6 months or more, with or without an interview. They have EAD-AP combo card, but we were hoping that they'll get their green card soon. If they have to go to India for 3-4 months, health issues of a parent, will it be okay to travel on their AP? Absolutely. As long as their AP, not the I-94, as long as their card is not expired, they can stay outside. Before the card expires, they must come in. Okay. If they receive their green card while they're in India, I just discussed that issue a moment ago, that if they are in India, they get approved, they should return. And when they return, they'll be allowed to enter because CBP can see that their green card has been approved. And they have a valid advance parole to come to USA anyway. So that should be fine. They can stay in India as long as their AP does not expire. If the advance parole expires, their 485 is deemed to be abandoned. Okay. If they do not receive green card by the time they return, any issues at the immigration? No, no problem. Chakri, if you're on the phone, press star 5. Okay, you're calling from India. I can see that. Go ahead, please. Go ahead, sir.
Yeah, hi sir. Actually, it's not about this question, but it's about the clarity. I mean, the line is a bit disturbed. I mean, your voice is a bit disturbed. Earlier when Lokesh spoke, it was clear.
Really? Okay.
Yeah.
Can you hear me okay now? Can you hear me okay?
Yeah, I'm able to hear you, but
okay, let me ask everybody else.
But it's breaking.
Yeah, I can hear you very clearly. Let me just ask everybody else if they have the same problem. 1 second.
The conference is now in conversation mode.
Hey guys, can you all hear? Can you hear me okay, everyone?
Yes, the voice is a little flaky.
A little flaky, huh? Okay, next time I'll try to log in through the high definition. Okay.
Hi, Rajiv.
Yeah, hang on. I'm not.
If you're using a speaker,
right.
Instead of that, could you use a headset, maybe, or headset?
Actually, I am on a camcorder, so a webcam. I'll do something next time. Our conference has a web interface to speakers also. I'll try using that. We'll experiment next time. Fortunately, the quality of the recording would be very clear, so you can hear me quite well in the recording. Okay. Let me get back to the call. I've noted the issue. We'll work out a solution for the next call. Thank you, guys.
We can hear you clearly now, but
it comes in and out. I use Skype to call into the conference because that way the recording is clear. Maybe I'll get a soft phone of some kind instead of Skype. So we'll work it out. All right.
The conference is now in presentation mode.
Actually, I just also realized we have a dual WAN connectivity. So we have 2 wide area network connections, and they are put on round robin. So they are load balancing and they are round robin. And I've noticed that sometimes when I log in with one connection, when I log in, my voice is clear, and sometimes it's not. It depends upon which connection is serving me. Maybe I can do a protocol binding if I know which protocol is being used for the Skype calls. I'll figure it out. I'll have my IT people look into it. And we'll probably bind the protocol to the better wide area network connectivity. We'll work it out. Okay. Going back to, so Chakri is not here. If you are here, press *5. Chakri, *5. Okay. Let me go on to the next question. Now, this is Sandhya 25186 who's getting sued by the company for $30,000, or they're saying because you're joining the end client, give us $30,000. The client refused to pay. Is this rule valid in California? Sandhya, the problem is this is a state law issue. This is only marginally an immigration law issue. You need to talk with a lawyer in California who practices in the area of contract law. There is definitely an immigration component to it. That discussion can be taken up once you have had a chat with a lawyer in California who does contract litigation. Okay, I cannot really tell you much whether the contract is valid or invalid and what the laws of California are. Immigration law is federal law. We can practice that for clients coming from any state. But state laws are confined to the state, and I am licensed to practice state law only in DC and Virginia. So I can't really comment about California law. Even if I knew it, it would be unethical for me to comment. Shankar Somashekar says, oh, he's an old client of ours. Well, good. I'm very glad to hear from you. But you know, Shankar, it's been a while. I don't remember what we did for you. But you know, I'm old. I forget things too. I'm on H-1B with I-140 approved in EB2 category. Priority date is stagnant, etc., etc. Okay. So I'll have to transfer my H-1B and my green card will start again. The reason I'm considering this position is because my current project has multiple layers in between and H-1B extension is due. I cannot find fault with that, but you know, the problem is if your employer revokes your I-140, USCIS's current thinking seems to be that you will lose your priority date. So I'm not sure how you feel about that. Let's go back to your question. Does having multiple layers and multiple vendor contracts increase the risk for an RFE? In isolation, without looking at the entire context of the situation, it's difficult to answer that question. If you are able to get an end client letter, usually your chances are pretty good. Is it wise to take up the new offer and restart the green card? Well, your priority date is 2011. That's a good 4 years. Not so sure. If your company promises you and they will not revoke your I-140, then I'm okay with you changing jobs. Otherwise, I would have to think long and hard. Okay. And for your H-1B, really the bottom line is how cooperative and helpful your end client is in providing the documentation that the government needs. Of course, truthful documentation, not to make things up. Will I get my perm and I-140 approved in another 6 to 9 months? May or may not. If you go into audit, after audit, if you go into supervised recruitment, it could take years. If I miss the next cycle, what might be the anticipated time? I think it's an incorrect decision. You should discuss it with your lawyers. If you are here, I hope that you are. I would be very careful. The only way I would move is if the employer is willing to forego the revocation of the I-140. Otherwise, I would not recommend it. It's too many years. Any updates on Obama's executive order? Not yet. It is on the regulatory agenda of the government for this fiscal year, but this fiscal year ends in September, which is just next month. So hopefully they'll have it again on the next year's fiscal agenda, regulatory agenda. So far, we've not seen any movement on it. Are you, I'm sorry, I should have asked. Shankar, are you on the phone? Press star 5. Shankarji? Okay. Um, let's go to Potter P385. He says, thanks from everybody's side. Are you very welcome? It's my pleasure. I enjoy it. Changing employer after I-140 approval. I have I-140 approved with March 2014 date with my current employer. Second year of H-1B. I'm thinking to change employer for a better opportunity. So you lose about a year, few months, 3-4 months. But they'll start the green card process after 1 year. So then you end up losing about 2 years and 3-4 months. My current employer A says if I change the employer, he will withdraw, cancel the approved I-140. You cannot port the priority date unless, once the case is I-140 is revoked, unless USCIS changes its current thinking, you will lose your priority date. You cannot port it. That's their current thinking. I'm not sure what else I can tell you. That's pretty much the way they are looking at the law. If you're on the phone, press star 5. Anybody has a follow-up question on this issue, press star 5. No new questions yet, please. Okay. Let's go on to the next question. Amit Surve, this is also somebody I've talked with several times. Oh, somebody just raised their hand. Go ahead, please. Go ahead.
Hello.
Yes, sir.
Similar question, Rajivji, right, for the last two questions what you discussed. So priority dates are now stagnant at 2008, and if as far as the Obama executive or action concern, getting EBD for 140 approved. So what kind of movements we do see in the next fiscal year? Because as we mentioned, USCIS is revoking the priority dates if employer cancels or withdraws the 140, because now it's basically folks who wants to change a job, they are now stuck, or they don't have any other options. Since the dates are also not moving, or there is no movement also on the EAD part for the 140.
I don't really have a crystal ball that is any better than yours. All I can do is make wild guesses like everybody else. But common sense says the population of applicants is not decreasing. The number of available green cards is not increasing. So the chances are we are going to be about the same, or maybe a little bit worse, or maybe a little bit better, but not a whole lot better. We could get a whole lot worse though. So impossible for me to predict. I can't really give you anything more than that. Okay?
Okay.
Good luck, sir.
Thank you.
You're welcome. Okay. Amit Surve. Wife is completing her 6 years on J1. Going to India for 2 years, you have 2-year home residency requirement, the 212E. If my 45 gets approved, they'll have to do follow to join, yes. Will we be able to file for H4 visa now as I'm on H1? I don't remember, sorry, I'm not sure if I did not put down the hand. Oh no, this is a new question. Let me get to that. Go ahead, you had a question, Indiana? Indiana?
Rajiv, to the previous question about changing the employer after the I-140 approval, let's say my employer A applied on an EB2 status, EB2 category, and my I-140 is approved. Now I'm planning to move to employer B, who is willing to start the process again, but in EP3 category. And if my employer A doesn't revoke my I-140, can I port the priority date to the different categories?
Yeah, your question is, can priority dates be ported from EB2 to EB3 or EB3 to EB2? Yes, no problem.
Thank you.
You're welcome. Alrighty, let's go on to the guys. Be a little quick with your hand raising. It interrupts our conversation otherwise. Okay. So back to Amit ji. Um, can we file an H4 if somebody has a 212E restriction? I don't remember. I think the 212E, I know for sure you can't, of course, do H1 or L1 or green card, but you can do things like O1, F1, B1 while you have 212E requirement. But can you do an H4? I'm not sure, but if I remember correctly, Section 212E of the Immigration and Nationality Act says that you cannot convert to H status during the 212E restriction. So please take a look at the law. We can do a consultation for you, although I think that information should be able to be garnered from many different sources. You don't have to, pay us for that. But I don't remember exactly off the top of my head. My guess is H4 is not permitted. Is there any provision that I could postpone 485 pending case? Not really. You can withdraw your 485 and wait as long as you like, as long as the job is available, and file 485 later on. But that's not going to help your case much. I'm trying to think what would be a good way to do it. I think one way to do it is what does your wife do? Let's see. Um, I hope you're on the phone. Amiji, if you are, press *5. I need to know a little bit more about your wife's profession. *5 if you're on the phone. I've talked with you before. Your name is very familiar. *5. Okay, you're not here. So one of the things I was thinking was if she could start working for a multinational company and then come back in on L1 after um, her banvas of 2 years is over, then she can convert to she can do a change of status, adjustment of status while she's on L1 in the United States. So the following to join does not require that she must follow to join from the consulate. She could follow to join with the 485. That's the only thing I can think of. H or L1 visa. If she comes after 2 years on H on L, she can then change status, adjust status within US. I don't think postponing 485 for you is a good idea. Can the process be started before completion of 2 years clause? I think yes. I think we've done it that way. We had a physician, sort of your situation. The husband was an IT guy, wife was a physician. She couldn't get a waiver job. She had to leave. So I think we started her 824 earlier, and we were able to postpone the interview date a couple of times. And finally, when she went for the interview, she had completed her 2 years home residency. But double check this. This thinking of government keeps changing from time to time. I would send an email to the consulate just to double check. I think starting the process is no problem. She cannot be approved for a green card until 2 years are over. Okay. So I guess you're not on the phone. *5. Follow-ups on this. *5. Okay. Let's go on to the next one. Are we cool? I guess we are. I'm a fresh applicant for H1B, selected in lottery. I have a dual degree from 2 different universities, BCA and BBA. Does USCIS consider it 3+3 is equal to 6 points or only 3 points? I don't know what points means, but if you have 2 3-year bachelors, they don't become a 4-year bachelors. They don't. If you have a 3-year bachelor's and then a master's in the same field or similar field, you're okay. But if you have 2 different bachelor's degrees and both of them 3 years, that is not good enough. You have experience in the IT field from 2009 onwards. So you've done one in BCA and one BBA from 2009 to 2012. As long as you have 3 years of professional experience in your field, you could qualify. Okay. Even if you cannot prove because the companies are a business, if you have other evidence such as tax payments and stuff like that, you should be okay. So I don't know what point systems is, Rahulji. You asked about point system. USCIS can verify the employment in India. I strongly urge you to be truthful and not fall to the temptation of making things up. What is the timeline to process the application? That's a difficult question to answer. You can always premium the pending case. That's not a problem. So if you have 2 3 year degrees, you must have at least 3 year experience in the field, professional level. Okay. Uh, any follow-ups on this? Star five, guys. Star five. SPSN, who's signed as Anne. Prior to getting married, I had a B1, B2 visa. I've also got H1 approved. B1, B2 was not cancelled. Can I hold 2 visas? People do it all the time. Consulate gets lazy. They are supposed to cancel existing visas before they issue the current visa, but they don't. And if for some reason H4 doesn't pan out for you, I see no problem with traveling on a B1, B2. But you can't enter on 2 statuses. When you come to the port of entry, present your H4. Another B1, B2 visa on your passport is no problem. This happens all the time. Star 5 if you have follow-up questions. Star 5. Nanny visa from Shalom 001. I guess what you're talking about is H2B visa. First of all, let me make it clear. It used to be that you could get an H2B for people from pretty much any country. Now H2Bs are restricted to citizens of certain countries. So unless you are a citizen of that country, you can't be issued an H2B visa or a nanny visa. India is not one of the approved countries. So people who are coming from India will not be able to get an H2B visa or a nanny visa. If an US naturalized Indian, immigrant wants to get somebody from, I think Nigeria is one of the countries allowed, or one of the allowed countries, they can. The individual who's hiring could be born anywhere, but the individual who's being hired, the so-called nanny, would need to be born in the country or citizen of the country. I forget which one is which. Citizen of the country that's on the list. Okay. I would like to know if by doing the nanny visa it will impact my I-130. Why should it? I don't see any reason for it to. Okay. Your country of birth is irrelevant. If you're on the phone, press star 5. Star 5 if you're on the phone, if you have any follow-up questions. Okay. This is a difficult question for me to answer for a couple of reasons. This is a question, I think, from an employer. And the problem is that I have 2 issues in answering this question. One, under the DOL regulations, employer is supposed to pay their lawyers. So I'm not sure how comfortable I am with giving free advice to employers. And second is an area of the law called assisting in unlawful practice of, what is it? Basically UPL, unlawful practice of, unlawful practice, something like that. So the idea is unauthorized practice of law. Thank you. UPL. UPL. So the problem is if somebody is acting in the capacity which is normally reserved to lawyers, and it involves interpreting situations and applying the correct kind of law, that is practice of law. Now you are okay to do that for yourself and your own company, but you can't give legal advice to employees of the company. Under Virginia law, that's a crime. Okay, so by offering advice to somebody who is engaged possibly in UPL, and I'm not pointing fingers at you, I could be assisting UPL, and that's unethical. So I'm not going to answer your questions. I'll have to go on to the next one. So Mamalik, I'm sorry, I can't help you. Next question is on H1B. Indian citizen H1B stamped in October 2011 was in USA 12 to 13, came back in 13, visa expired in August 13. Can I use the existing H1B? Okay, first of all, for counting the H1B time period, anytime you are outside USA, these are the rules. Anytime, this is true for both H1 and L1, anytime you are outside USA, even for 1 day, that would be counted out and given back to you as an extension of the H1 when you apply. It's called recapture. Okay, so even 1 day outside USA, you get it. And the way I understand the rules, if in any 12-month period, you are outside USA for more than 6 months, you can get the whole year back. And if you're outside for more than a year, you can reset the H1 or the L1 clock, but then you'll be subject to the quota. You get 6 years back and you become subject to the quota. Look at something called the remainder option. People who have been outside for more than a year can either be exempt from the quota and just get back whatever remains on their H1, or choose to be exempt from the quota. Choose to be subject to the quota and get all 6 years back. Okay, I think that's what you're asking me. Pankaj, if you're on the phone, press star 5. Star 5 if you're on the phone. Let me review one more time quickly, make sure. You're here already. Good. Let me just go ahead, please. I can hear you. Go ahead.
Yeah, hi sir. I wanted to know like what is the latest by which I can get the H1 visa renewed? Because my visa was stamped in 2011 and it got expired in 2013. It's been like 2 years since it has expired. So how long can I wait before I mean after which it gets expired like completely and I have to go for a fresh H1?
Okay. Let me start by saying this is the information I have from USCIS based upon the last time we addressed this issue. You know that as long as your H1 has been approved within the last 6 years on the date you apply for your H1, or on the date the H1 is adjudicated, let's be safe and say that, you are exempt from the quota. The question is, how do you count the last 6 years? So if your case was approved in 2011, would you then become eligible to apply only till 2017? Or if it was good till 2013, are you good to apply from quota exemption till 2019? So does the 6 year attach to the approval or to the finish date? And USCI has told us they look at the finish date. Double check this, but from what I understand, this is what they are saying.
Okay, so it will be 2019 for me.
That's the way I see it. Double check it. I caution you because this is based upon verbal, oral communication. I have nothing in writing that says so. Okay?
Okay.
Good.
One more question.
Yeah. Go ahead.
So currently I'm working for a new employer, and I have discussed with them about renewal of this visa. So they said that they are in the process of it. So will it be a new petition that they would apply, or it would be an extension of the petition?
Well,
I mean, how would
that's
this work?
just nomenclature. Their lawyers will fix that for them. The bottom line is they would apply for an H1 and they'll claim you as quota exempt. Okay.
Okay.
Good luck.
Okay. And
Yeah, make it real quick. I have a lot of questions to answer still. Sir?
generally, how much time does it take for a petition approval?
I do not know. That's variable. Apply for premium processing if you don't want to wait. That's much quicker.
Okay.
All right?
Okay.
Good luck.
Thank you.
You're welcome. Toronto has a raised hand. Toronto, go ahead, please.
Hello, sir. Good afternoon. My name is Rajiv Rakesh.
Yes.
I have to question my visa issue on August 2008 after one.
I'm sorry. I'm going to have to put a stop to this conversation. I'm only answering the posted questions right now. Okay? Sorry. Let's go on to, I just answered Pankaj Kulkarni's question. Venki 1. I have an EB2 priority date of May 2011. New job offer is on the table. They'll start my green card. Grace Estrado decision, what does that have to do with priority date and employment-based cases? Not sure. Um, there is nothing. I'm not sure what does that have to do with priority date. I didn't think that has anything to do with employment-based cases. Let me double check that though while we are talking. Well, I'm looking at some of the things that Grace Estrada stands for. This is a non-presidential decision. Oh, I was not aware of this decision actually. I thought this was an I-130 based decision. Thank you for letting me. This is something I didn't see. But it's a non-president decision. That means it's not binding. I'm not sure how this is. This is exactly in line with the. What? Uh, I'm reading a comment from an expert. It's absolutely nonsense. I'll tell you what. The regulation is actually quite clear. You don't have to go into all these details. The regulations, if you look at them, 8 CFR 214, are very clear. That's why I didn't pay much attention to this decision. It would have crossed my desk because it basically says that if your old employer revokes your priority date, you will lose your priority date. Revokes your, I'm sorry, I-140. But that's in line with the government thinking. So Grace Estrado has little to do with any of the I-140 filings. First, it's a non-precedent decision. Second, the regulations appear to be quite clear. USCIS had in between changed their mind, and I'm not sure they could. I'm not sure that that was entirely legal, but they were holding that we will let you keep your priority date if the employer revokes the I-140. The only time we'll take away the priority date is if the priority date, if the I-140 has been revoked for fraud or misrepresentation. So until something changes, and in this case, something would be an amendment of the regulations, I suspect you are going to lose your priority date after the I-140 is revoked by the old employer. I don't think there's any way around that. Venki, if you're on the phone, press *5. I read just an opinion, just a couple of lines of the opinion, and I saw that this is basically the same thing that has been floating around for a few months now. I actually looked at the regulations when I saw a decision from the government saying you can't keep your priority date, and I did not have much to argue because the regulations were clear. Okay. Venki, go ahead, please. Venki, we can hear you, Venki. Go ahead. What happened? Okay. I guess you can't hear me. All right, next question. Ravi Kumar, I have my POM approval, priority date 2013. I'm going to change. They'll cancel my green card. Another employer, a future employer, is willing to start my green card. When can I move to that employer so that my old employer will not have enough time to revoke my old green card? Well, the only time it would be safe is once I-140 is approved and 485 has been pending for 180 days. Then you actually don't even need a green card filing. You just need a job offer. Before that, it's not safe to move. Is it possible for employer B to clear both perm and I-140 if I'm not working for them? Absolutely. Priority date porting would require you to be in I-140 approved, 485 pending, 180 days to be safe. Otherwise, you'll lose your priority date. Nothing else would save you. Star 5 if you have a follow-up question. Ravi, if you're on the phone, star 5. Okay. I'm wondering sometimes we have people on the phone, but I'm wondering a lot of people who post probably cannot attend the call because it's the middle of a workday. Maybe we should start doing it on Saturdays or something. I don't like to work weekends, but maybe that would be more beneficial to people. Okay, let's go on to the next page. Rohmal is on H-1B working full-time. New employer has filed the H-1 transfer. The transfer documents were sent on July 28th. Last working day with the current employer was July 31st. Look, if the filing of the H-1 transfer was received by USCIS while you were still in status, still working, you are fine. You can be unemployed as long as you have to. You're not losing status. Okay? Rohmal, if you're on the phone, press star 5. If you're on the phone, press star 5. Any follow-up questions? All right. Next question is Monarch. This is a CSPA issue. You had sent me an email, a mail on LinkedIn, I think. So the question was, sister filed petition on May 5th, 2003. So that's an I-130, I'm assuming. I hope you're on the phone. Approval date is 4th August 2009. So we've got almost 6 years. Almost 6 years of pendency of the I-130. Under the CSPA calculations, that can be taken out of the child's age. So your child is 24 years old. Under CSPA, taking away 6 years, he will be considered to be 18 years old. So he should be fine. CSPA should protect him. What should you do? You should contact the Mumbai consulate, preferably through email, explain to them I-130 was pending for 6 years. The child today is 24. Under CSPA, he clearly qualifies for his green card interview. Please schedule him as well. Email, there's no other form for it. Email them right away, please. Okay? Are you on the phone? Press star 5 if you're on the phone. There you are. Okay. Now, interestingly, your number is not an India number. Okay. Go ahead. I can hear you.
Hi, Rajiv ji. My question was actually the previous one. I have pressed star 5 times, but it did not work. I had a question actually.
Okay.
So you said if they have received my package, I wouldn't be out of status. But I have no information that. I have not got my EAC number once they receive the package, and the check has not been cleared yet. So am I still out of status?
Well, there is a difference between proving and the fact itself. When we file papers, we make sure papers with deadlines, etc., are filed through a traceable service, whether it is USCIS's, whether it's the United States Postal Service's overnight registered mail or FedEx. We mostly use FedEx. We used to use UPS as well. But most of our petitions go through FedEx because we can track the packages. So if it can be proven that the package was delivered, you are quite safe.
Oh, I see. Okay. Thank you, sir. Thank you for your help.
You're very welcome. Good luck, sir. Okay. Where was I? Oh, Monarch, you're not on the phone. Well, in India right now it is what? Afternoon? Morning, I guess. Yeah, about 10, 11 o'clock. Okay. Uh, Prof. Guy says, I'm from India. F1 was refused 9 years back under 212A6. So is that some kind of a fraud? See, fraud is a permanent bar. And I don't remember if 9 years ago the same law applied or the law today, which permanently bars entry, retroactively applies to acts before the passage of the law. Unlikely, but I don't know for sure. They are applying an H1B. See, the 212A bar, which is the fraud bar, usually is a permanent bar. The only waiver you have is called a 212D3 waiver, and that's only given for the duration of the visa. You won't have it. This is not a way around the permanent bar. You still will be subject to the permanent bar. So you can't do a green card because you are permanently barred if you have the fraud misrepresentation bar. Somebody has raised their hand and I'm not sure who it is. Let us see. This is Louisiana. Go ahead, Louisiana.
Hello, sir. This is Raj, and actually, I was trying a couple of times to start live, but somehow it's not connected. I have a follow-up question, like what we were talking about I-140. So, can I ask, like,
Yeah,
quickly?
go ahead. Of course, that's all right. Go ahead.
So, sir, my question is that after 180 days of filing, like approved I-140, after 180 days, can any company revoke the I-140?
Let me make sure you understood what I said. I-140 approved, 485 pending 180 days. Okay, so
Yes. So,
I-140 should be approved. Then, if your priority date is current, or unless Obama's law comes into being, you can file 485, and 485 must be pending 180 days. Then you become quite safe.
But priority date right now is the 2030,
So,
and
so you're not free. You're not free until you filed 485, and you cannot file 485 under the current law until priority date is current. So you're stuck for a long time.
so let's say it's one year over now. Company can revoke the green card, this I-140, and then if I change the job, then I'll not. There's chance that I'll not get my old priority date.
That is correct.
So
Okay.
is any way I can take a steps to like so that new employers do the required things to retain my priority date?
Well, it's not in the hands of the new employer. It's in the hands of the old employer. If they revoke the I-140, you're going to lose the priority date.
So sir, I was reading I mean, on some website, but I'm not sure. Like there it was mentioned that after 180 days, no employer can revoke the I-140.
Either you misread or they are misinformed. There is no third way about it because that is not the law. All right, I gotta go. Good luck.
Yeah. Okay. Thank you, sir.
You're welcome. Okay. Guys, I can't defend somebody else's opinions. I don't know what they're thinking. So really, that's a useless exercise. So I answered the question about the fraud misrepresentation. Shweta has a question. She says, I always listen to these calls to update my knowledge about immigration laws. Well, it's funny. I once walked in a friend of mine who was listening to one of my TV interviews and she was fast asleep. And I said, what the heck? You have this tape that you have of the TV interview. She says, it's the best thing I know to fall asleep to. It's so boring. I fall asleep right away. So maybe I hope you're not in the same category. You are misusing the recordings. Anyhow, can a candidate call the USCIS directly to ask questions about their H-1B? The answer is no, because USCIS does not consider an H-1B or an I-140 to be your case. which is very unfortunate because you are the one who's getting the most affected. But so far, that is the problem. What is the process of changing from one job title to another when they don't fall into the same occupation? So let's say you have an MBA and you are going from being a programmer or a systems analyst to, let's say, an operations manager. Okay, totally different job title, totally different requirements. You would have to file an H-1B amendment, even if it is the same employer. Okay, H-1B amendment. Shwetaji, if you have any questions and you're on the phone, star 5. Okay. Next question is Caffrey. Harassment by the employer, shady practices, not paying while on bench. You left because they stopped paying you. You know, the employer could be in a lot of trouble. All it takes is filing WH4, I think that's the form. WH stands for Wage and Hour Division of the Department of Labor, and they have to investigate by law every credible complaint they receive. And once Wage and Hour Division shows up, an employer who has practices like that, they can pretty much close the company down. They can even take him to criminal prosecution. Employers are dumb if they mess with employees and their own houses are not clean. So every corporate employer that we work with, we insist that they view immigration as a part of their enterprise resource planning, not just as filing two forms. You know, I would want to know, do you have a practice of benching? That's a part of your infrastructure. If you do, you've got to change that practice. Otherwise, you could be in a lot of trouble. Any employee picks up the phone or goes to WH4, you've got an auditor sitting outside your door. Next thing is, what was the largest amount of fine paid for immigration violations? Several $1 million, actually. Okay. So, it's not a good idea for an employer to do that. Is there any rule that I need to give notice to my previous employer? There is nothing, at least in Virginia or DC laws. I can't comment about other states, which requires any kind of notice. Unless there's a contract in writing signed by you, you are not required to give any notice in these states. You can check on your own states. Immigration law certainly does not require any notice. If they start harassing or making calls, you call the police. Okay, so you can certainly file a WH4 complaint and request that the complaint be kept confidential. I have seen a Department of Labor letting slip the name of the complainant. As far as I know, they're not supposed to. They're supposed to keep the identity confidential. But sometimes if it's one complaint, they might just ask for your files, and then it becomes clear who filed the complaint, which is not a problem because if they take any adverse action against you while you're working with them, you're protected by whistleblower laws. If they come after you any other way, I think filing a police complaint is a very good idea. Okay. If you're on the phone, press star 5. Any comments, questions, guys? Star 5. Okay. Victor 25 says, experience letter for I-140. Previous employer is not giving it, but I can get it from the middle vendor. You know what you can do? We've had this situation before. Company closed down. We had close to 28 employees from the same company that closed down. How do we prove their experience? So we got letters from middle vendors and end clients and showed that the company had closed down. There was no way for us to get the primary evidence. So get together with your lawyers, but at least theoretically, anybody in the chain of your employment who knows what you did can give you that experience letter. Okay, very good. Star 5, any questions? Victor, if you're here, star 5. I'm going to start new questions now. Okay, anyone has any question? Oh, 1 second, somebody. Victor, is that you? California?
Yeah, hi, Rajiv. Are you taking your questions?
Oh, okay. Let me put you on hold for one. Let me put you on hold 1 moment, okay? All new questions, *5, and I'll take questions in the order you logged in. *5, 2, that's easy. 2, 2, 2, 2. You know, it's interesting how on my screen, just the calls that I see in front of me, Canada, Florida, California, Louisiana, North Carolina, Virginia. This is so interesting how we from all these different places come together in one forum. Very gratifying. 4 people so far. Okay, 3 people. One hand went down. It's a toggle. Okay, it came up again. If you press *5 twice, it goes down. You press it 3 times, it goes up again. Okay, so 4 questions, 4 people are all we are going to deal with. No fifth one, please. Okay, that's it then. In the order that you called, first somebody from India who was the one of the first callers. India, go ahead, please.
Hello.
Yes, sir.
Yeah, Rajiv, currently my work type is my employer puts me in US on H or L visa. And if I want to take my mother, who is a widowed mother, and she is 66 years old, can she travel on B2 and stay with me for a longer period apart from the 6 months that is for this case?
Yes, yes. Um, there is a provision, a policy provision in the laws that says some people, guys, this is now we have 5 people raising hands. I will not take a 6th one, please. If you have a question, raise hands because I budget my time accordingly. You know, no more questions after that, please. 5 questions, 5 people. Okay, so coming back to your mom's issue, there is a provision which was used a lot by actually gay people. So if I am gay and I want to bring my partner, I can't do an H4 for them because in those days, gay marriages were not, same-sex marriages were not recognized. Then people used to come on tourist visa. It became a part of the law that some cases, for example, a child turns over 21, but they are still dependent upon you. You could bring them on a tourist visa and keep getting extensions in the United States. We've done it many times. In fact, if you go to our, I haven't updated that for a while, been so busy with different things. And you know, the team just keeps sending me all their write-ups about the new cases, and they're just sitting on my desk. I have to review them. But in our cases from our files, we have several examples where we were able to do extended B extensions for people in your mother's situation. Okay.
Is there any specific set of documentation or eligibility that is there?
No, it is just a tourist visa that keeps getting extended. The visa doesn't get extended, but the stay keeps getting extended. Okay.
Okay. All right. Thank you.
Yeah, bring her with you on a tourist visa. And once you are here, after a few months, ask for an extension from USCIS and let them know that you intend to continue asking for extensions. Okay. Please stop raising hands, guys. I'm going to be very tired. So now there's 6 people with questions. Okay. Well, I hate to turn anybody away. I'll do 6. Please, please, please stop it. It's not, you know, it's just very indisciplined for us to not come out in the first instance. Okay, sir, bring her in on a tourist visa and keep getting extensions. Call me back in when she's here. I'll guide you further. Okay, sir?
Okay. Thank you.
You're welcome. Good luck. Okay. Next, the person who logged in, let's see. This is Indiana. Indiana, go ahead, please. Indiana.
Hi, Rajiv. This is the last question in the forum.
Right.
You didn't answer that. Maybe I missed.
No, I actually did. I answered that in the very beginning. So once I post the recording, your question and the first question in the forum were about the same. So I discussed them together. You may have logged in late.
Right.
Okay.
Sorry.
And if you still have questions, just go ahead and send me an email through the contact us form. Okay, I'll make sure they're included in the next call. All right.
Thank you.
You're welcome. Okay. North Carolina. Go ahead, please. North Carolina.
Hi, Rajiv. So this is Raseshwar. I sent you an email. You have email
Oh,
regarding
remind me.
traveling after biometrics.
What was your question?
The possibility of traveling after the biometrics.
Possibility of traveling after the biometrics. Are we talking about?
Our 485 was filed with 765 in EAD, and we recently had biometrics done. And I-31 was also filed simultaneously.
Okay, hang
So
on one
after
second.
biometrics,
Hang on one second. Do you have an H1 visa stamping or H4 or L1 or L2 visa stamping on your passport?
not on the passport. I do have I-787.
No, you have to wait until the approval of the advance parole.
Okay, sir.
All right. Good luck to you, sir. You're welcome. Okay. Let's go on to the last three questions. This one is Louisiana. Louisiana, go ahead, please.
Yeah, sir, one question that is any website where I can check how many I-140 my company revoked, and is it general practice that company they revoke the I-148 employee leave the company?
That's a very good question. Do they have to revoke by law? No. If I was their lawyer, would I tell them to revoke? Yes. Why? Because it impacts their ability to pay wages for other employees who are doing green card and working for them. And two, it just ties all the unclean ends neatly. If an employee has left, we should have standard practice to revoke their I-140. Now, if an employee has worked well with us and they have stood by us while we became a bigger and bigger company, and we want to not make sure that even if it costs us extra effort and risk, we want to protect them, I would keep their I-140 because there is no law that requires me to revoke it. Okay?
Okay, so sir, last thing is that I'm really confused. Like I hear so many things, and then I want to change my job, but the thing is that I want to defend my priority date also. So I'm really confused. Like, what should I do? Like, because my employer, I think they will revoke because it's TCS, they revoke all the I-140. So I'm really confused. Like, what should I do?
I think you are stuck if you can't have it both ways. You can't have priority date retention as well as change of employers if the old employer is going to revoke. The only thing we can hope for is the Obama plan comes into play because he said, I'm not going to make you wait to file 485 for your priority date. Once you file 485, after 180 days, you are free. Okay, but right now, there is no way to accommodate both interests. Keeping priority date and moving employers, not possible. Okay.
Okay, and sir, if my new company, if they will file, can they file without I join them as their like future employee?
I have already answered.
green card
I've already answered this question in today's call. Listen to the recording, okay? I've answered this
Okay, sir. Okay.
in
Thank
great
you,
detail.
sir.
You're welcome. Guys, I just sort of run out of steam. I've been talking for a couple of hours now. So let's go to two more questions left. One is California. California, go ahead, please. I have two Californians.
Good morning, Rajiv. Good morning, Rajiv.
Good morning, sir.
My 6-year H1 is expiring on September 25th, according to my visa stamp on the passport. But my unused course is October 2nd, 2015.
Usually, USCIS, hang on. Usually USCIS adds 10 days to the I-94 when it's the last H1 approval. So because you have
Okay.
10 days to leave after your H1 is over. You can't work during that time.
Okay. And say I am planning to leave on September 27th. Will I be considered out of status if I leave on that date when my company files for a new H1 next fiscal year?
Hang on, give me the dates again. When does the I-94 expire?
I-94 expires October 2nd.
And you are leaving on?
I leave September 25th.
No problem at all. Perfectly fine.
Okay. I can leave on September 27th and still not, and I won't be out of status.
Definitely, that's perfectly legal. No problem at all.
Okay. Thank you, sir.
Oh, you're welcome.
Thanks a lot for this.
You're very welcome. My pleasure. All right, guys. Last question of the day, and this is also California. California, go ahead, please.
Mr. Rajiv, my question is, my employer has filed for my green card, my I-140 is approved. I know that I have to wait until the priority date becomes current for filing the I-485. Does the consular processing option apply to me? Can I use that? And is that faster than waiting for the priority date to become current?
Does the what processing?
The consular processing.
Oh, consular. Oh, yes, of course. Anybody can convert to a consular processing case by filing. You have to file a form called I-824, and that takes a few months to go through. I think it's probably over 6-8 months. But then your file will be sent by USCIS to National Visa Center in New Hampshire, and eventually it will make its way to the consulate.
So I don't have to wait for priority date to become current.
No, that's a misunderstanding. Priority date has to be current whether you are going through consular or 485. No question about that. Because they won't issue you a green card until your priority date is current. Don't think it's any faster to go through consular processing. No, sir. Okay.
So in terms of timeline, it does not offer any advantage related to.
Absolutely zero advantage. No advantage whatsoever. Okay.
Okay. All right.
Good luck to you. Now, I would hate to do this to you, but you have again raised your hand, despite my saying several times, I'm done, don't raise hands anymore. All right, since you're calling from Canada, one more shot. Go ahead, please. Ontario, Canada, go ahead.
Hello, sir. Good afternoon, sir. My name is Rakesh, and I have one quick question. My visa issued August 2008 and expired on April 2011. Still subject to quota or no? I'm in Canada, sir. I want to come back on H1 or TN.
TN is no quota. If you are a Canadian citizen,
but H1 is if company want to sponsor me H1, I can able to come by my I-485 still pending since 2006-7.
I think
my priority date is.
I think there is
July 2006.
I think you are exempt from the quota because the dates of your approval are within the last 6 years. Okay.
Then exit. And sir, I can come on if TN company willing to hire me on TN, but I come my I-485 still pending. Is get problem?
Your case is a little bit more complicated than you can discuss in a conference call. You need to get together with your lawyers because if you have left USA, your 485 is probably gone. Okay. I can't discuss it in 5 minutes that we have here. You may want to talk with your lawyers, see what your situation is, but I can tell you this. If your H1 was approved and the term is within the last 6 years, I think you are quota exempt. Okay?
This one is again after 6 years finished, they extend on the other 3 years. Based on I-140 approved.
That is
9 years.
That is correct. So you should be okay. There are two different issues. Do I have time left on my H1 out of 6 years? You have no problem with that because your I-140 is approved. Am I quota subject or quota exempt? And I think you have no problem there also. I gotta go. Good luck, sir.
Okay, sir. Thank you, sir. So nice of you.
You're welcome.
Bye.
Good luck. Guys, as always, it is a delight and a pleasure to hang out with you. I'll see you again in 2 weeks. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.